and the Temptations. Like all the rest didn't matter. Gladys and the Pips. Right? Oh, I think I know the words, but I think I don't know the words. Irish. Forever, forever. Sure, Benny. I will put that up here. Thank you. Let's see here. I think I know parts of it. I'll be probably faking and mumbling the whole time until they get to that part. Irish. Oh, look, she about to drop them lyrics. Hey, good morning, pretty brown. Okay, let's see this old late judge. Let's see what he talking about this morning. So we can get them back in the jury room.
Case, and then we will ask you to deliberate. This is cause number 2024 CRG 00717D2, the state of Texas versus Billy Delgado. Members of the jury, the defendant, Billy Delgado, stands charged by indictment with the offense of aggravated assault causing serious bodily injury with a deadly weapon to a family member, a felony of the first degree alleged to have been committed on or about the first day of June 2024 in Webb County, Texas. The defendant has pleaded not guilty to these charges. Assault is defined as a person commits the offense of assault if he intentionally, knowingly, or recklessly causes bodily injury to another. Aggravated assault, a person commits the offense of aggravated assault if he commits assault as herein before defined and he causes serious bodily injury to the injured party. Bodily injury is defined as physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Family means individuals related by consanguinity or affinity as defined under sections 573.022 and 573.024 of the Government Code. Individuals who are the former spouses of each other, individuals who are biological parents of the same child without regard to marriage, and a foster child and foster parent without regard to whether those individuals reside together. Dating violence means an act by a member of the family or household against another member of the family or household that is intended to result in physical harm, bodily injury, assault, or sexual assault, or that is a threat that reasonably places the member in fear of imminent physical harm, bodily injury, assault, or sexual assault, but does not include defensive measures to protect oneself. Act means bodily movement, whether voluntary or involuntary, and includes speech. Conduct means an act and its accompanying mental state. Individual means a human being who is alive, including an unborn child at every stage of gestation, from fertilization until birth. Intentionally, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly means a person acts knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly, a person acts recklessly. A person recklessly causes bodily injury to another if the person is aware of but consciously disregards a substantial and unjustifiable risk that the person's action will cause bodily injury to another. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Count one, application, aggravated assault causing serious bodily injury with a deadly weapon to a family member. Now, if you find from the evidence beyond a reasonable doubt that on or about the first day of June 2024 in Webb County, Texas, the defendant, Billy Delgado, did then and there intentionally, knowingly, or recklessly cause serious bodily injury with a deadly weapon to a member of his family, to Erica Edith Torres, herein styled the complainant, by shooting at her person, and the defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the assault, and the complainant was a person with whom the defendant has or has had a dating relationship as described by section 71.003 or 71.005 or 71.0021B of the Texas Family Code, then you will find the defendant guilty of aggravated assault causing serious bodily injury with a deadly weapon to a family member as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. Justification, defense of a third person. A person is justified in using force against another to protect a third person if, number one, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using force to protect himself against the unlawful force he reasonably believes to be threatening the third person he seeks to protect. And number two, the actor reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using deadly force against another to protect the third person if, number one, under the circumstances as the actor reasonably believes them to be, the actor would be justified in using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. Number two, the actor reasonably believes his intervention is immediately necessary to protect the third person. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. The use of force or deadly force to protect the third person is not justified, number one, if it is in response to verbal provocation alone, or number two, the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates his intent to do so, and the other nevertheless continues or attempts to use unlawful force against the actor or third person, or number three, if the actor sought an explanation from or discussion with the other person concerning the actor's differences with the other person while the actor was unlawfully carrying a weapon, a person who has a right to be present at the location where the force or deadly force is used, who has not provoked the person against whom the force or deadly force is used, and who is not engaged in criminal activity at the time the force or deadly force is used, is not required to retreat before using force or deadly force to protect a third person. In determining whether the actor reasonably believed that the use of force or deadly force was necessary, you may not consider whether the actor failed to retreat. On the issue, when the issue of the application of defense of a third person is raised, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant's conduct was justified by the defense of a third person, you must find the defendant not guilty. Application of the law to the facts in that regard, you must determine whether the state has proven beyond a reasonable doubt that the defendant, Webb County, Texas, on or about the first day of June 2024, intentionally, knowingly, or recklessly caused serious bodily injury to Erica Edith Torres by shooting at her person, and that the defendant used or exhibited a deadly weapon, namely a firearm and or G3C 9mm Taurus, during the commission of the offense, and that Erica Edith Torres was a person with whom the defendant has or has had a dating relationship. You must agree on all of these elements, but if you do not have to agree which culpable mental state, that is, intentionally, knowingly, or recklessly, the state proved. If you find from the evidence beyond a reasonable doubt that the defendant is guilty of aggravated assault, as stated above, you must next consider whether his conduct was justified by the defense of Esmeralda Delgado. If you all agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you will acquit the defendant and say by your verdict guilty. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must next decide whether the state has proven that the defendant's conduct was not justified by the defense of Esmeralda Delgado. To decide the issue of defense of Esmeralda Delgado, you must determine whether the state has proven beyond a reasonable doubt at least one of the following three elements. The elements are that number one, the defendant did not reasonably believe his conduct was immediately necessary to protect Esmeralda Delgado against Erica Edith Torres' use or attempted use of unlawful force or unlawful deadly force. Or number two, the defendant did not reasonably believe that Erica Edith Torres was using or attempting to use unlawful force or unlawful deadly force against Esmeralda Delgado. Or number three, under the circumstances as the defendant reasonably believed them to be, the third person would not have been justified in using force or deadly force to protect himself or herself against the unlawful force or unlawful deadly force of Erica Edith Torres. You must all agree that the state has proven beyond a reasonable doubt at least one of the three elements listed above. You need not agree on which of these elements the state has proven. If the state has failed to prove at least one of the elements beyond a reasonable doubt, then the state has failed to prove that the defendant's conduct was not justified by the defense of Esmeralda Delgado, and you must find the defendant not guilty. If the state has proven at least one of the elements listed above beyond a reasonable doubt, then the defendant has proven the defendant's conduct was not justified by the defense of Esmeralda Delgado, and you must find the defendant guilty. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all of the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required, however, that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all of the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. You are the exclusive judges of the facts proved, the credibility of the witnesses, and the weight to be given their testimony. But the law of the case you shall receive in these written instructions and be governed thereby. After you retire to the jury room, you should select one of your members as your foreman or presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreman or presiding juror. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No person has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through the officer. Any communication relative to the case must be written, prepared, and signed by the foreman and shall be submitted to the court through the officer. Do not attempt to talk to the officer who has you in charge or the attorneys or the court or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause and restrict your deliberations solely to the issue of the guilt or innocence of the defendant. Following the arguments of counsel, you will retire to the jury room to consider your verdict, and we will await your unanimous verdict. You have one verdict form attached, ladies and gentlemen, where you find the defendant either guilty or not guilty. Please make sure that the presiding juror signs the correct line indicating your unanimous verdict. Ladies and gentlemen, not in the charge, but I just want to tell you orally, every court treats notes differently. I encourage note taking because if it assists you in concentrating on the evidence, I want you to do it. But it is important you understand that although you were permitted to take notes during the testimony in the case, in the event you did take notes, you may rely on your notes during your deliberations. However, you may not share your notes with the other jurors, and you should not permit the other jurors to share their notes with you. You may, however, discuss the contents of your notes with the other jurors. You shall not use your notes as authority to persuade your fellow jurors in the deliberations. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and counsel. Notes are valuable as a stimulant to your memory. On the other hand, you might have made an error in observing or might have made a mistake in transcribing what you heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of the evidence during the trial. Occasionally, during jury deliberations, a dispute occurs as to testimony that was presented. In that case, you shall inform the court and request the court read that portion of the official transcript. You will not rely on your notes to resolve a dispute. If you do have a dispute, specify what it is in writing, and that portion and only that portion will be read back from the official transcript. With that, ladies and gentlemen, both sides have been given an hour to argue the case. Should they elect to use it, the state does have the burden of proof, so they have the right to open and close the arguments. I'll ask them to address you at this time.
Thank you, Judge. May I please the court? Counsel, ladies and gentlemen of the jury. You're free to choose, but you're not free from the consequences of your choices. What did Mr. Soto say in opening statements? This was a case about choices and consequences. And how on June 1st of 2024, that man sitting right there made a fateful choice that has consequences for which he must be held accountable for. Now, what choice did he make? He chose to commit the offense of aggravated assault of a family member with a deadly weapon, which resulted in serious bodily injury. Let's go over those elements. You heard testimony when it comes to on or about June 1st, 2024, from the investigators that responded to the case, from Investigator Lopez to Amasquita, Mark Vela, Florencio Barrera, how they got a call and they were dispatched to 2420 North Smith Avenue for a shooting call. You heard the victim, Erica. She took the stand and she testified that she went to Billy Delgado's residence because he called her over because of some issue with her daughter. Let's move on to the second element. In Webb County, Texas. It happened on 2420 North Smith Avenue. I asked Officer Amasquita, and even Erica testified, that residence is located in Laredo, Texas, which is in Webb County. Let's move on to the next element. The defendant, Billy Delgado. What evidence do we have? Well, we saw Officer Amasquita testify. We saw his body cam. You'll be able to take that with you in the back. He confessed. Yeah, I shot her mom. Who's her? Emmy, his daughter, who happens to be Erica's daughter as well. We see Juan Angel Pina surveillance footage, and we see it point blank. Look, it's right there, point blank, aiming a gun right at Erica through the passenger side window. Erica IDs. I heard 3 shots through my windshield, and as I drive by, I see Billy shooting, pointing a gun at me. And let's not forget the forensic scientists that came over and confirmed that there was gunshot residue on Billy Delgado after Mark Vela got samples from his hands and sent it out for testing. But ladies and gentlemen, the most important one, he confessed on June 1st, 2024. He confessed back then, and he took the stand, and he confessed on the stand as well. Check, check, check. All right, let's talk about the next element. Intentionally, knowingly, and or recklessly. Well, it started May 19th, prior to June 1st. Erica and Kayla took the stand, and what did they say? Erica said on May 19th, almost 2 weeks prior to the date in question, Billy told her, enjoy your birthday, because this will be her last one. Kayla overheard that same conversation and could confirm that's what Billy said. So he had a plan already. He had a plan that he wanted to execute. And execute he did. There he is. Look at State's Exhibit 4. He's laying in wait. Erica's up there. You see her coming in a green Kia Soul. He's laying in wait, waiting to ambush her to execute that plan. And execute he did. What did Florencio Barrera say? In my experience, he was about 5 feet away from her. He didn't fire one shot to eliminate a threat like he's going to later claim. He fired 10 rounds. He had a purpose. A man with a purpose, walking with a purpose. State's Exhibit 5 will show the other angle of Pina's home surveillance footage. And what is he doing? She pulls over in distraught. He's walking with a purpose, fidgeting with his pockets. Go, look at it. He's fidgeting with his pockets, touching his gun. He goes back to his apartment, and he puts his gun. Oh, and what else did he put up there? 2 loaded magazines. He didn't get to finish the purpose he set out for. He gets arrested once Amasquita gets her, and what does he say? I emptied a whole clip in her mother. Again, who's her? Emmy. Mother being Erica. He was in handcuffs in the patrol unit, talking to a neighbor, and you can see it on Amasquita's body cam. And what does he tell this neighbor? What am I supposed to do? I'll just deal with the consequences. He took the witness stand as well, and he admitted yesterday, he took the witness stand and he admitted to shooting her intentionally. Now, let me talk about serious bodily injury. Now, you're going to get the law from the court, which you already did. It's right here. The definition of serious bodily injury is here. Let me discuss it real quick. Serious bodily injury is bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. What did Dr. Mederos come? He came here on his busy schedule and he took the stand. And what did he say? He said that if I did not intervene and do the medical treatment and surgery on Erica, she would have 100% had a chance of dying. That at any time that he was doing his surgery, his laparotomies, as he called it, which he did twice, by the way, to save her, that at any moment she could have died. I asked him on page 17 of the medical records, and you'll have him in evidence. What does hemorrhagic shock mean? He defined it for us. And I asked him, if that were to be left untreated, what could it result in? He said death. That her pH levels are below a certain level, to the point that if somebody has them and if they're not treated, they die. That's what she had. pH levels below the level he described to where she could have died. Ladies and gentlemen, bodily injury that creates a substantial risk of death or that causes death, check. I think we got that. We've proven that beyond a reasonable doubt. But let's continue. He also talked about how, and that's page 17, ladies and gentlemen, on the medical records, they're in evidence, how she lost 4 liters of blood. And I asked him, had they not been replenished, what could have happened, Dr. Medeiros? She would have died. And he goes into discussion about, he discusses in detail how much blood she had to be replenished. And it's in the records. He also testified that she's going to suffer from short gut syndrome, meaning a large part of her intestines were cut out and she doesn't have them. It's going to affect her ability to get nutrients, to live a long, healthy life, be able to do certain activities that you and I take for granted. She spent 363 days in the hospital. That's close to a year. Losing a large part of your intestine. Let's go back. Protracted loss or impairment of the function of any bodily member or organ. Check. This is how that man left her. This is the picture on the right. That's 4 days prior to today. 4 days. And look how we left her. I believe she even testified that she still had a staple, and you can see it right there. Oh, but yes. She did come in walking normally and looked fine. Okay, yes. Serious permanent disfigurement. Check. I asked Dr. Medeiros, are you familiar with the legal definition of serious bodily injury? And he said yes. I asked him, as to all 3 possible definitions, do the injuries that Erica sustained at the hands of Billy Delgado, would you, in your medical opinion, classify them as serious bodily injury? And he said yes to all 3. As a matter of fact, he took the stand up here and even said, yes, I caused serious bodily injury to Erica Torres. That's another element that we have proven beyond a reasonable doubt. Now, who is our victim? You heard it from the horse's mouth. She came up here. She testified as to what she experienced, what she went through, what she remembers, what she didn't remember, not because she was trying not to remember anything, because she literally couldn't remember because of what he did to her. We saw Pina's home surveillance footage where she's driving her green Kia Soul. And how do we know she was driving the green Kia Soul? Because Kayla testified that she drives the green Kia Soul. Kayla also testified that she was on the phone as Billy was raining bullets at Erica. And again, he confessed back then on June 1st, 2024 to Officer Mesquita. And he confessed again when he took the stand yesterday. Another element met beyond a reasonable doubt. Let's talk about the deadly weapon element now. Deadly weapon. So again, you're given the law by the court, by that man right there, the judge. He gave you the law. It's in here. A deadly weapon, we know automatically, we call it per se in our legal terms, but it's automatically considered a deadly weapon, a firearm. We know State's Exhibit 6 right here. Y'all can check it out. Y'all can take it back and look at it. Investigator Juan Lopez sees a black Taurus G3C pistol. I asked Lopez and I asked Mesquita, Officer Mesquita, is a Taurus G3C pistol considered a firearm? Yes, it is a firearm. It's meant to kill. We look at Pina's home surveillance footage. And actually, I can go back. You can see the firearm he used right there on his hand. Erica described it. And he admits to it too. You can see an offer on Mesquita's body cam. Where did you put the gun? Oh, and I believe, quote for quote, oh, it's on the chair right there on the black chair. Sure enough, that's where it is, with 2 loaded magazines. And then again, he took the stand yesterday and he testified that he did use a deadly weapon. Ladies and gentlemen, there's another element meant beyond a reasonable doubt. Let's go to the final element. So again, the court has provided you the law. Here's the law. This, it's going to be right here with you. You take it there and you go read it and you look into it. You base the evidence and see if it matches, if it qualifies. 71.003, family includes individuals who are former spouses of each other or individuals who are parents of the same child without regard to marriage. Section 71.0021B talks about dating violence. So in this case, it's committed against a victim, Erica Torres, with whom the actor, that man right there, Billy Delgado, has or has had a dating relationship. Ladies and gentlemen, we heard from Erica. They dated since 2018. They got married on March 21st of 2021. They divorced 2025. In between, June 1st, 2024 is when the actions that Billy Delgado took, that shooting, happened in between. They were married when he committed that crime. Married. So, satisfied. Oh, they both testified. Erica took the stand. Billy took the stand. Yes, we share a daughter, Emmy. Individuals who are parents of the same child without regard to marriage. Satisfied as well. So, ladies and gentlemen, based on the evidence presented, the state of Texas has proven beyond a reasonable doubt that each element of the offense alleged against Billy Delgado has been satisfied. On top of the mountain of evidence, ladies and gentlemen, he confessed back then. He confessed on the stand yesterday. You should find him guilty, beyond a reasonable doubt, of aggravated assault of a family member with a deadly weapon causing serious bodily injury. Now, I anticipate defense is going to come up, and I anticipate that they're going to deflect from the situation at hand. And that's that. Not focus on the choice that man made and the consequences that he should be accountable for, but focus on the victim and how she's a bad mother and how she looks fine and how she's a bad person, airing out all her dirty laundry. Ladies and gentlemen, she took the stand herself. She aired her dirty laundry for you. She didn't need them to do it. She went up there and she told her faults. She admitted to them. I also anticipate that they will probably argue that, well, Billy did what he did because he had to defend somebody. In this case, he had to defend Emmy. You're going to go back there and there's going to be a defense of third person. And defense of third person using force to protect himself against the unlawful force he reasonably believes to be threatening the third person he seeks to protect. And important, the actor reasonably believes that his intervention is immediately, another important word, immediately necessary to protect the third person. Okay, so he's trying to protect Emmy from who? This Uncle Louis, who never made an appearance in this case other than just him saying it. As a matter of fact, we brought you Investigator Vaquera. They looked into it, the multidisciplinary team. There was no merit in that allegation. There was nothing there. So why pursue when there's nothing there? They did their job, investigated it. Protected from him? From Louis? Protect from what? From Erica? Because he was going to take Emmy back to Louis. Well, if I recall from the testimony, Billy was supposed to have Emmy until Sunday. Erica was supposed to pick up Emmy on Sunday. No, he calls her a day before. Hey, I'm having issues with her daughter. Come get her. So a day before Erica was supposed to have Emmy, he calls her over. So he calls Erica, who may be a danger to Emmy, over on his day where he's supposed to have his daughter. Remember, Emmy was in his apartment eating pancakes that he happily was making for her, playing with toys that he gave her, according to his roommate's testimony. What danger was she in? There was no danger. There was no immediate danger. There was no danger at all. He called her over to execute his plan so that he can ambush her and kill her. And he executed that plan, but he failed. And luckily he failed because she was able to come up here and testify for you and tell her what she went through, tell you all what she went through, instead of being 6 feet deep. And Judge, I'm going to go ahead and yield the rest of my time to Mr. Sullivan.
All right. Thank you. That was 18 minutes. Defense.
May it please the court, opposing counsel, ladies and gentlemen of the jury. Let me address you. I'm not going to be yelling at you. I'm not going to be showing you gross pictures to try to deflect you from the issues at hand, okay? So what are the issues at hand? The state seems to believe that it's just an aggravated assault with serious bodily injury. As you see in your jury instructions, you're going to see that it says when the issue of the application of defense to a third person is raised, which it has in this case, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant's conduct was justified by the defense of a third person, you must find the defendant not guilty, okay? So they're going to try to disprove defense of a third person by argument, okay? Argument. They didn't put up any evidence up there to say that there was not a defense of a third person. They failed. So it's just not those things that he showed up there, check, check, check. He forgot to check this one, okay? He didn't check this one because they failed to do it. They could have called Uncle Louis to come up here. Did you do it? No. Disproved, okay, of our defense. They had to be immediate. It had to be an immediate threat. That's why he didn't wait till Sunday. If you want to take care of it now, okay? If it wasn't immediate, he would wait till Sunday. If he wanted to ambush her and kill her, he would have waited till Sunday. She was going to come over, okay? It didn't flow that way. It doesn't flow right, right? In his brain, and how does his brain get in this position? Will we be here, first of all, if he wasn't abused all these years? Would we be here? Probably not, okay? So remember how he's been shaped over these years. He threw a weight at him. They hit him several times. She told you she's been arrested for beating up her own brother. And her words are laying hands on somebody. Okay, she got arrested. Okay, Billy says that she's got friends in high places. Nothing happened to her. You know, we talked about second chances. How many chances does she have? Her brother, Billy, several times. She admitted to drinking with her kids in the back seat. One of her kids. That's a felony offense here in Texas. Anything happen? Okay, keeps going over and over in his mind. That's what he's thinking. Okay. And it's in the instructions what a reasonable person is, okay? It tells you at that moment what he's thinking. And it's just not that moment. It's everything that pushed it to that moment, okay? The abuse, psychological abuse, verbal abuse, the physical abuse, it shaped him. Okay. I can't get any help. Okay. Because of her friends. Nothing's going to happen. He's had enough. Now something's happened to his daughter. So he's got to act. And he acted. That's what it was. Now there is a jury instruction for that. The state can't disprove it that he did it to defend his daughter. Okay. She's being abused. They even told you during voir dire, I believe. They said, we have a single witness rule. All we need is one witness. The state always does that. Well, in this case, we have one witness of the abuse. And guess what? It doesn't matter. It doesn't apply. It doesn't apply now. You heard it. Did you go talk to the guy that did it? He just got out of prison. If I was a cop, that's what I would do. The guy got out of prison. Let me go see what he wants to tell me. Okay, maybe he'll confess. I don't know. I called him. I couldn't find him. It's good enough for me. She didn't say anything. Her mom just got shot. Dad's in jail. The kid clams up. And the end of the case. That's the end of the case. Okay? The kid goes back to the same situation, the same family where the abuses occurred to Mr. Delgado and to her. That's the end of that case right there. And who knows what that child's going to be a product of in the future because of all the abuse that's going on. It's we weren't disputing any. We saw the video, ladies and gentlemen. They didn't need to bring an expert to say there was gun residue. Okay, nobody's disputing that. Nobody's disputing the shooting. We're disputing why it was shot. Why did he shoot? Okay, that's the whole issue. Do you need to take a look at the at this? We have the instruction. The judge thought it was that it weren't merit for you to take a look at. Okay, that's why it's on here. There's evidence to back it up. If there was no evidence, we wouldn't get this instruction. So we have evidence. Take a look at it. The state has to disprove it before you get to a guilty verdict. Okay, they didn't put on any evidence to disprove it. They're going to try to argue it. What the lawyers say is not evidence. Okay, what lawyers say up here is not evidence. It's what comes out of that witness chair. Okay, whoever's up there. All right, you heard Erica's cousin say she had it on speakerphone and I could hear Billy was calling where I said, it's going to be your last birthday. When Erica testifies, what does she say? Go drop off the kid. He straps her in, comes over to my car and says, it's going to be your last birthday. So they didn't get that story straight. All right. Because there's two different versions. All right. So it's different. And why would he say that? Why would he, if he wants to kill her? I mean, just do it. Could have done it right there when he dropped off the kid. Why didn't he do it? Because it's not true. All right. He had plenty of opportunities, plenty of abusive situations when he got dropped off in the middle of the night. Hey, leave the house. I don't care. They're stuck in traffic. They're trying to exit so they can drop her off going to San Antonio. What does she do? Gets her kids and starts walking down the freeway. I mean, what kind of mother does that? Okay. Wait till you drop me off so my kids are safe. It's not about your kids being safe. Okay. It's about her. All right. It's unfortunate that she got shot. It's horrible. Billy told you, I regret it. I didn't want to shoot her, but he had to do it to protect his daughter. Right. In his mind, it was just that moment. And I told you during voir dire, I said, if I could judge you for your worst 5 minutes of your life, what would be my verdict on you? All right. And that's what you're going to be doing to Billy. 5 minutes when you should be considering the 4 years that we're together. All right. Take a look at the entire picture. Don't focus in on what they're trying to show you. They're going to show you gross things and bad things, and they say all these things. Do you really need to get those issues proved? I mean, really, it was a shooting. She's injured. She was the wife. They've already done that. Get to the good stuff. Okay. Show me how you disprove that the little kid was not abused, that he was trying to protect her. Show me that. They're going to have words. They're not going to have evidence. Okay. No evidence. So they can't disprove that. And because of all that, you have to find him not guilty because they can't disprove it. It's their burden, not mine. I raised the issue. They needed to put up evidence. They didn't do it. So it's a verdict of not guilty. That's the reason you get to not guilty, not because there was no weapon, not because they weren't dating, not because of the other issues. It's because of that. Okay. And all of this was focused toward a prosecution, and it's more vindictive. It's more of anything. I mean, Who would take pictures of your daughter to go show your granddaughter or have her later so she can examine it? I mean, nobody does that. Those are horrible pictures to be able to show, to come back. Look what your dad did. Okay. That is just absolutely incredible. All right. And you know, they were praying for Erica. She made it. She survived. You know, but part of the Lord's Prayer is, you know, forgive me for my sins as I forgive those who trespass against me, right? So in this case, that doesn't apply. It's all vindictive. It's all funneled to try to get him punished, okay? Mr. Delgado's already been punished for a lot, all right? A lot of abuse, a lot of just torment that he's been through. And this was his expression when he couldn't do anything to protect himself. He had to protect his daughter, and he acted. Okay? Make the state prove all the elements of the offense, which includes now the justification. Can they disprove it? Did they put up any evidence? They didn't put up any evidence. Okay? So be looking at that. They're going to put on some more stuff, say some other stuff, but remember what lawyers say is not evidence. It's not. So in your back of your mind, when he's talking about there's no justification, make him go back and say, that was my evidence. So you can analyze that. Check with your notes, okay? And part of, as for the Delgado family sitting over there, and Mr. Delgado, we thank you for listening to our case, okay?
May I proceed, Your Honor? Yes, please. Thank you. Good morning, ladies and gentlemen. Defense just came up here and told you he's not going to show you any gross pictures. He's not going to do any of that stuff. Ladies and gentlemen, these pictures that we're looking at, that the defense calls gross, are the result of what his client did that day. These are the results of what Billy Delgado did to Erica Torres as she drove up innocently, unsuspecting of the assault that she was about to suffer. I'm sorry that he thinks this is gross, but this is Erica's life now because of what the defendant did. Now, he said his client's been through torment, that he's been through a lot. What has Erica been through? Billy Delgado's a healthy young man. He can walk, he can talk, he can jump, he can run. Erica fought for her life. She has bullet holes to remember every single shot she received from him. And then he told you they brought words that the state only brought words, that we didn't bring evidence. Ladies and gentlemen, we brought a mountain of evidence. We brought a confession. He even told you on the stand, I did it. He confessed to every single element of the offense. And I want to bring your attention, if you could all grab your jury charge, please, and let's turn to page 5. If you look at that top line, it says, under the justification, because this is what they're arguing. He's saying that they have a justification. If you look at that top line, under the circumstances, as the actor reasonably believes them to be, and pay attention to that word, reasonably believes, the actor would be justified in using force to protect himself against the unlawful force he reasonably believes to be threatening the third person he seeks to protect. Now, reasonably believes. To reasonably believe, you must be able to use what? Reason. You must be able to reason with what you're doing. Yet, when he took the stand and I asked him about shooting Erica, I blacked out. When I asked him about shooting her multiple times, do you remember? I don't remember. I can't remember. He conveniently blacked out. He conveniently doesn't remember. He remembers being in the apartment, and then he remembers the cops showing up. So where was he able to formulate this supposed reasonably believe? Where was he able to use his reason when he's conveniently blacking out throughout this entire process that he can't recall? Ladies and gentlemen, it's an excuse. This is a lie, another lie by the defendant. Just another excuse to justify his actions of what he did to Erica that day. Just the same way he made up the lie about this supposed sexual assault against his daughter by Uncle Louis. The only person that's ever cried wolf about that is the defendant. He's the only person, because Emmy's never told anybody else. She's never told anybody else about it. And let's just say, for the sake of argument, that you see reasonably believes, you need to prove and, because that's the next word. The next word means that reasonably believes to be threatening the third person he seeks to protect, and. So you need to do both. You need both for the justification of defense of third person. So, and the actor reasonably believes, so again, he's got to use reason, but apparently he was blacked out through this entire process. Blacked out because he couldn't recall what he did. He couldn't remember thinking about what to do or how he did it because he was blacked out. The actor reasonably believes that his intervention is immediately, at that point in time, immediately necessary to protect the third person. The third person, Emmy, who's in the apartment upstairs, that he left Emmy with his roommate. You saw Estrada take the stand. She said Billy dropped off some toys and he told Emmy to play and for me to watch her, that he was going to go talk to Erica. There's no immediacy. Where's the immediate danger? There's no Uncle Louis, the supposed cry wolf that's outside waving, I'm here, Billy, I'm here. He called Erica over to the house. He told her, get here now, come pick up Emmy. I can't do this no more. Why lure her there? If you're going to do the right thing, call LPD. Do what a normal person would do. Call the police or say, hey, Erica, look, I'm not going to give Emmy back. We need to figure out what to do about this. Okay? I'm going to keep her. I'm going to keep her with me. I'll give her back to you after we talk to the police. There was no immediacy, ladies and gentlemen. There was no immediacy. So this doesn't apply. And then even then, when the issue of the application, if you turn to page 6, please. When the issue of the application of defense of a third person is raised, the burden of persuasion is on the prosecution to disprove the justification beyond a reasonable doubt. And defense told you we can't disprove that we can't disprove that beyond a reasonable doubt. Ladies and gentlemen, it's like I told you in Fort Dyer. This is common sense. We use common sense every day. Every day. You heard the defendant. I blacked out. I blacked out. I blacked out. There is no evidence for his reasonableness. There's no immediacy. Again, just another excuse. So let's talk about what this case is really about. Like I said, defense would have you believe that Billy did this because he was triggered by what happened to his daughter. Well, then why Erica? Why shoot Erica? She didn't do this. If you were triggered by this, she's not the one who abused Emmy. If this is supposed incident that happened pushed you over the limit, she's the wrong person. Why not take the proper measures like I just told you? Call the police. He bragged about his family being in law enforcement, how his grandmother was the captain of police. If that's the case, then you know police will do a good job, right? You know they'll do their job if you just call and take the proper measures like a normal person. Two wrongs don't make a right. Two wrongs don't make a right, ladies and gentlemen. He doesn't get to take justice and be the judge in this case. What he did is not justified by any circumstance. What he did to the mother of his child. And that case was closed. There was no evidence. There was no outcry. The child was interviewed by a trained professional in a controlled environment, in a comfortable situation where there was no time limit. And Investigator Baquera told you the child never outcried to any abuse. They gave her a doll to even say, you know, where has anyone ever touched you in any of these places? She never outcried. They gave her an anatomical drawing where it shows the outline of the human body. And they ask, do you know your private parts? You know, are these areas that no one's supposed to touch you? Right? And has anyone ever touched you here? She never outcried after all the opportunities that she had. So of course the case was closed because that was just an excuse, a lie that the defendant made up to shoot and to try to kill Erica Torres that day. Defense would have you believe that Billy is a victim of violence. He's a victim of violence based off a 2-minute and 30-second video, a self-serving video. I'll have you at that. Ladies and gentlemen, if I go home to my wife, I know all the buttons to press. I know what to do to upset her. And if at that point in time, after I've riled her up, and I say, oh, leave me alone. Hold on. Let me put it in selfie mode real quick. Okay. Stop. Yeah. Ladies and gentlemen, come on. That was a self-serving video. We didn't see the circumstances leading up to that. Erica told you herself. She took ownership. She said, I needed to get to San Antonio. Well, why didn't you get off? He was driving on the highway. I couldn't get off. Well, why didn't you try exiting the vehicle? It was moving. My kids were in the back. And why were you so concerned? Because if I missed court, I would get arrested. And I would stay in custody until I had court. And I didn't want a warrant out for my arrest. I'm sorry, ladies and gentlemen. Yes, she was upset. She was upset because she was being held against her will when the defendant had told her that he would take her to court in San Antonio. But in the video, you hear him say, we were late. We weren't going to make it anyways. She still made it that day, even after getting dropped off, or she didn't get dropped off. She jumped out of the car while it was in between two trailers and walked to the truck stop, waiting for her mom to pick her up. And you saw in the video the defense like, no, please. Yeah, I'm tired of this. And what does he do? He looks down to make sure that he's showing his face. Y'all saw him. He looked down. And then, we're going to crash. We're going to crash. What does he do? Afterwards, he pulls up the phone. He's like, all right, let me take it off selfie mode. Let me close it. Yes, he was very concerned about crashing while trying to record a video after he was starting a fight, after he was fighting with Ms. Torres, and she was upset because she didn't want to get arrested. I don't blame her. I don't blame her for not wanting to get arrested. Nobody wants to get arrested. And meanwhile, being held against her will, right? Because she couldn't get out of the moving vehicle. Defense would have you believe that Billy did this because he thought he needed to protect his daughter. Ladies and gentlemen, we already talked about this. There was no immediacy. There was no threat. Emmy was upstairs, locked, or not locked, but in a room with the door closed. I'll have you, because Erica Estrada texted, she said on the stand that the door was closed while she was in the room with Emmy. The front door to the apartment was closed, and Billy Delgado walked outside, apparently conveniently to his benefit. He was blacked out, but he told you, I always carry my gun. I always have my gun. It's small enough for me to carry it. I'm not a convicted felon. I can carry a gun. Ladies and gentlemen, where's the immediacy? Erica didn't rev her engine and pull up. No, she's just pulling up nice and slow, ready to pick up Emmy. And what does she hear? Bang, 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 bang. Yes, Mr. Delgado felt threatened. Ladies and gentlemen, common sense. And most importantly, he called Erica to come over. That's what you need to go back to every single time. He called her there. It wasn't her day. It wasn't her time to pick up Emmy. Emmy was supposed to get picked up on Sunday. It was his visitation. But the defendant lured her there. Why? Because he wanted to ambush her. He wanted to attack her and knew that she wouldn't stand a chance, that she wouldn't suspect it. He wanted to kill her. Like I told you, this case is about choices and consequences. We all have free will to make choices. You heard Sharon Estrada. Billy was making pancakes that morning. He looked at peace. He looked at peace. Ladies and gentlemen, if you're upset and if Emmy told him this the night before, why not call PD that night? Why not call Erica that night? The moment you just got told that when he claims that his daughter, she jumped in my arms and she was crying. Get the phone. It's not like LPD only works 8 to 5. Call her mother. Let her know. I called the police. I just got told this. No, ladies and gentlemen, because that didn't happen. Erica testified. Billy called her to come over to his apartment to immediately pick up their daughter. He told her, get here now. She told you she was at a friend's house. She dropped what she was doing because she said, Billy told her, get here now. Come pick up Emmy. There was no immediacy. Billy created this situation. He created the situation he wanted. He made a plan to execute Erica Torres. What did Dr. Medeiros tell you? When we asked him about serious bodily injury, all the different definitions, he said, she did everything but die. So we met serious bodily injury. She lost her blood volume. She will have difficulties for the rest of her life. And she will need to be monitored because she will never have a normal life ever again. But at least she can walk normally or look like she walks normally. Use your common sense, ladies and gentlemen. We brought you the pieces of the puzzle. Remember, I said we were going to bring you the pieces of the puzzle, and it may not be a complete puzzle, but you'll be able to make it out. We brought you the videos, the shooting. We brought you the interview. Look at that video. There's no remorse. He looked like nothing. You know, instead of saying, how's Erica? Is Erica okay? Is Erica okay? Instead, he's like, look at my rap sheet. Look at her rap sheet. I don't got nothing. She's been arrested. In his eyes, he thinks of her as less than dirt. Look at the way he treated her that day, the mother of his child. He had the opportunity. Billy Delgado called Erica and ambushed her that day. So we've brought you the videos. We've brought you the opportunity that he had. We've shown it to you. The weapon and the casings, all 10 casings. We didn't just bring you the casings. We brought you all of them. All 10 opportunities he had to kill her. The confession, he told you he did it. He told you here to your face that he did it. Not only did he see that, he said, I did it. I shot the mother of my child. I'll deal with the consequences. He told you on the video when he was arrested, and he told you here in court on the stand. You saw her serious bodily injury with Dr. Medeiros. And they were still married the date of the assault and share a child. So we've proven our case. We've proven that on or about June 1st, 2024, in Webb County, Texas, the defendant, Billy Delgado, intentionally, knowingly, or recklessly caused serious bodily injury. Remember, I told you in voir dire, intentionally, go up to show someone directly, point a gun at them, right in front of them, boom. That's intentionally. Knowingly, you see a group of people together, you shoot, you know you're going to hit them if you're aiming at the crowd and they're all jam-packed together. And I said recklessly. When I explained recklessly was that you can appreciate the standard, but you do a gross deviation from it, regardless of the outcome of your actions, right? So even if you think that Billy Delgado says, well, I was just shooting at the car, I wasn't shooting at her. You shoot at a car with somebody in it, you're disregarding the fact that they could get hit. You're disregarding the fact that they could die. You're disregarding the fact that they could get seriously injured. And he did all of those. He intentionally shot at the car. He knew she was going to get shot. And he disregarded that fact when he recklessly shot at her in the car. So all of those three intentional elements are met. And used or exhibited a deadly weapon. A firearm, automatically a deadly weapon. And he also admitted to you, yes, I used a deadly weapon on the stand. During the commission of the assault, namely a firearm and or a G3C 9mm Taurus. This is what he used that day, ladies and gentlemen. Not only what he used in the firearm that he was carrying, this is the one that he likes to carry, right? Has he told you that he always carries a gun? But he was also accompanied by its two buddies, 2 loaded magazines. Ladies and gentlemen, he had one intent that day. It wasn't to talk to Erica. He wanted to kill her. He wanted to hurt her. He wanted to remove Erica from Emmy's life for his own personal, selfish motives. And like I said, we've satisfied the family dating relationship. You've heard about their entire relationship, right? You know the truth. Remember in voir dire, I told you, can we know exactly 100% exactly what happened that day? No, right? I told you, because the only way you know is if you were there, if you saw it. Ladies and gentlemen, not only did we show you the acts of Billy Delgado that day, we brought the crime to you. You saw it with your own eyes. You all saw the actions, the lack of remorse. At no point was there any hesitation. And you'll see the video, play it as many times as you want. She pulls up, and without hesitation, he points his firearm and just starts unloading, one after the other. He's not moving. And I know that there was some argument by defense. Well, if he wanted to kill her, he could have killed her. Ladies and gentlemen, if this is the car, he was right there in front of it. He was trying his best to aim. He had a mission that day. But what do we have? We have Billy Delgado still hiding behind his excuses. I blacked out, or I did it for my daughter. Which one is it? You can't have both. You can't have both, ladies and gentlemen. I did it for my daughter to protect her. Okay, well, then you did it? Well, no, I blacked out. Those are completely contradicting statements. That doesn't make sense at all. You did it because you wanted to protect your daughter, but you don't remember doing it because you blacked out? You know why that doesn't make sense? Because it's a lie. It's an excuse for his actions. His own mom told LPD. She testified. She didn't believe Billy. She doubted him. She told LPD, there's no way. She told you on the stand. Yes, I said there's no way this could have happened to Emmy. She would have told me. Emmy's a talkative child. Well, if she's a talkative child, of course she would have told her. She would have picked up on it. She even told you, yes, I check her underwear when she comes from her mother's. Ladies and gentlemen, she said that on the stand. Your own mom doesn't even believe you. And she tried to stop him. You heard her, that she was talking to him right before he did it. Was he blacked out? Or was he using reason when he talked to his mom? Because he told her, watch this. And then he put his phone in his pocket and boom, 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 boom. But he was blacked out, like he told me, right? He was blacked out. No, ladies and gentlemen. He was trying to execute his own motives. He had an agenda. He had a plan to lure Erica there and execute her. Sharon Estrada, she talked about the box of toys. But I want to talk to you about how, did you hear how she said it? She said it on her own. He looked calm. He looked at peace that morning. If he was so triggered, if he was so bothered by what he heard the night before, how are you going to be in the morning looking calm and at peace? I would be ringing the phones. I'd be ringing the bell. I'd be at LPD banging on the door saying, open up, we're going to talk about this. And I'd be there with my daughter saying, something happened. Remember in Fort Dyer, when we discussed unhealthy relationships? I talked to you all about unhealthy relationships, and we discussed how, yes, maybe we or people we know are involved in unhealthy or toxic relationships. And I asked you all, I said, if someone chose to stay or if they were part of an unhealthy relationship and they suffered abuse, is that abuse justified? And you all took a note and you all said, no, just because somebody is part of an abusive relationship or they were part of an abusive relationship, that doesn't mean that their abuse should go unpunished, that it should be allowed. You all said that and you all agreed. And that's why we're here, to hold Billy Delgado to his actions. It is time for him to face his consequences. Ladies and gentlemen, Erica Torres, she fought for her life. She fought for her life to be here to tell you her story. All 363 days, she fought for her life so that she could have her day in court. And she could come and she could take this stand and tell you about the pain, the suffering, and the actions that Mr. Delgado caused to her. Multiple individuals testified. They said that they believed she was going to die. Officer Luis Castillo, off duty, told you, I was pretty sure she was going to die in front of me. Dr. Madero said, if she did not receive medical help, she was going to die. Erica told you, I was trying to get to the hospital. I didn't want to die. Kayla told you, Kayla de la Cruz, she told you she needed to get to the hospital. She was going to die. And let me remind you about something. Erica Torres is not on trial. This is called the state of Texas versus Billy Delgado. That's what this case is called. The victim is not on trial here. She is not on trial. Why? Because she is the victim in this case. And we are here for the actions of Billy Delgado, for what he did, for what the defendant did, for what that man sitting over there did to her. That is why we're here. We're not here for the state of Texas against Erica. And she took the stand. And yes, like my co-counsel told you, we heard their dirty laundry. But you know what? I'll tell you something that she did. She owns it. She takes it. She takes accountability for what she did. She was on probation for what she did. She takes accountability for her actions. But you know who doesn't? The defendant. Because lie after excuse after excuse, his actions he still believes were justified. No, ladies and gentlemen. You heard when I asked his tia, his aunt, I said, Nobody deserves to get shot, right? 10 times? Yes, I asked her, no woman deserves to be shot 10 times. And she agreed. Nobody deserves that. Nobody. Billy Delgado made his choices, and now it's time for him to face the consequences. So, when I'm done here, you'll go to the back. You're going to turn to the verdict form, and it says, we, the jury, find the defendant, Billy Delgado, guilty of aggravated assault, causes serious bodily injury with a deadly weapon to a family member, felony of the first degree. And you will sign right there under guilty. Thank you, ladies and gentlemen.
Members of the jury, I'm going to excuse you with the exception of Mr. Pedroza and Mr. Nunez. If you would stay with us momentarily. I need to talk to you all outside the presence of the other folks. Ladies and gentlemen of the jury, don't begin your deliberations because they may have some stuff in the jury room. I'm going to let them come in there and get whatever they left. And then as alternates, they're going to be excused. So once they leave, you begin your deliberations and only discuss the case when all 12 of you are in the room. If somebody goes to the restroom, stop the deliberations and wait till they return. So we will await your unanimous verdict. If those two jurors would stay with us momentarily, would everyone rise as the jury goes to the jury room?
All right, the jury.
So while they rising for the jury, thank you, Paula. Thank you, Libby.